Okay, so we'll start. We'll kind of run back through this. Sorry about that. I forgot to start that. All right, let's go back. Let's do the slideshow in the beginning. So just as a observation, couple of observations from this, what I'm seeing is that this listing agreement just is it tends to be much more general listing agreement, broad base. The execution date will be the effective date, so that's consistent. The addenda should be used, so those 28 or 29 different addenda that currently exist, you should use those as part of the listing. Similar to what we do now with the NEFAR purchase listing agreement, we use the homeowners association disclosure, the CD disclosure. You want to make sure that you add those to this. You're going to have to add a lot more detail for clarification. The onus is going to really fall onto us to make sure that the seller is clear on what's being offered and what the process will be like. This is going to challenge us to prepare a more detailed marketing plan for our sellers. Leaves most of the items to the negotiation with the buyer. So really what this does is really just say that we're the brokerage that has the listing. It's an exclusive right of sale listing agreement. And let me back up a little bit. If you're looking for these forms in app files or anyplace else, this is really just titled the exclusive right of sale listing agreement. You have to look deep into it to see that it is exclusive right of sale listing agreement transaction broker, or exclusive right of sale listing agreement single agent, or exclusive right of sale listing agreement no brokerage. In most of the platforms, the title includes single agent transaction brokerage, no brokerage, but in the form it doesn't. So it's easy for you to get lost. And where that really appears in the form on these listing agreements is in paragraph 10 when it talks about the brokerage relationship. It's not even in bold. It defines the relationship based on the form that you've chosen. So I would love to see them change the title so it's clear, but it doesn't really. You have to be careful when you're picking out or when you're selecting forms to use, because there's a couple of others that look very similar. The wording is very similar. There's a exclusive brokerage agreement, which can be confused with that comes under listing agreements, but can be confused with the listing agreement. Two very different things. Really relies on us understanding our obligation through the code of ethics. And this is where I think we're going to get into a lot of trouble, is something as simple as the code of ethics that defines that if you're not working in a transaction brokerage relationship, you must disclose at the first meaningful contact, which would be at the time you make an appointment to show a property, or when you're writing an offer you included into paragraph currently 17, that naturally that will change. The same thing applies here. Is we're going to need to make sure that we're understanding the code of ethics. And when it comes to listing agreements, the code of ethics and the Florida statutes really dictate how we act with the sellers. The NEFAR listing agreement has done a great job of kind of helping us to stay on track. This one, again, being very broad strokes. Remember, we're going from 9 pages to 4 pages. And the 4th page of this document is really all signatures. So you're really going from 9 or 8 to 3. So pages. So there's a lot of stuff that's been pulled out. We'll talk about all that. There is a greater obligation to the agent for detail and requirements, process detail and requirements. Again, when you're doing your seller's consultation, this is going to be a really important time for you to discuss what your value propositions are and what your marketing propositions are, because you're going to want to make sure that you're differentiating yourself. And we can say, well, once we're all on this listing agreement, why do I have to do anything different? Well, because you've had the opportunity to be supported through the NEFAR listing agreement, which guides you much more detail through some of the requirements. This one is going to leave it up to us as individuals to make sure our sellers are clear on what they're offering and what they're doing. So it becomes really, that obligation really falls to us. So things that are not in the FARBar, there is no primary residence acknowledgement. So currently, the seller has to identify whether or not this is their primary residence. There is no obligation to disclose whether or not that there is their primary residence. This puts again the obligation to you, the agent, to ensure that you're talking to the right people who have the opportunity or have the authority to list that property. Also, there is no notice of the spouse's requirement to sign. In the NEFAR listing agreement currently, there's a bold statement that says, look, if you bought this house, and this is paraphrasing, if you bought this house before you were married, and now you're married, and you and your spouse are using this as your primary residence, your spouse has to sign this. There is nothing there that says that in the FARBar. So again, obligation back to you to have the discussion with the seller. Are you the only person that we need to talk to? Is this your primary residence? Of course, you can see that in MMT and the tax records, whether or not they're getting their homestead exemption. Is there anybody else that needs to be engaged in the discussion of selling this property or signing these documents? So that notice isn't here, and it's always been a good reminder for us. So a lot of the things that aren't in the FARBar anymore were things that NEFAR put in as good reminders and guides for us. So we have to start thinking about those things. Personal property is not detailed, nor are exclusions. So both documents have the personal property early on, but I'm going to tell you right now, there's no detail. Now, there's a place in the FARBar that says, see attachment when it talks about personal property, but I would not recommend using the MLS profile sheet as the attachment to just say what stays and what doesn't stay. You're probably going to want to create some sort of acknowledgement of what items stay and what items don't stay with the seller, and then disclose those in some sort of a format. There's no, I'm not finding any amendment to the listing agreement. So I had a call in yesterday to the legal hotline just to kind of chat with them a little bit, but they were kind of booked up, which makes sense for a Monday and with all that's going on. So I'll try and get back and see what other things we can use so that I can make recommendations, or we can at least talk about recommendations on how to utilize or manage personal property. Again, they're pushing the personal property over to the purchase and sale agreement. The purchase and sale agreement has some detail in it related to personal property, but where's that leaves a little bit of gray area, because then the seller is not explaining in the NEFAR, the seller expresses what their desires are to leave. Naturally, anything can be negotiated in a purchase and sale agreement, but this doesn't even give the seller the opportunity to say, these are the pieces of things I would like to leave. These are the things I don't want to leave. And then when it comes to negotiation with the buyer, how they feel about what's being requested. So it really pushes it back to the purchase and sale agreement. I mentioned it before. The listing agreement for FARBar pushes a lot of the items into a lot of the pieces that we discussed early on, or that we've been used to discussing early on. It pushes them to the purchase and sale agreement and the negotiation that would occur. Do you have a question? Are we good? Are you good?
Yeah.
Okay. Closing costs are not detailed. So we're going to probably be requiring a closing cost profile with your listings, because we've got to discuss that with the customer, what's normal and customary. Remember, the survey is different on the FARBar purchase and sale agreement. Customarily, we've had the seller paying the survey. Now it's more common for the buyer to pay for the survey when you look at the purchase and sale agreement. Doesn't detail that in the FARBar. So closing costs are not detailed, what's normal, customary. But I will tell you that even though it doesn't detail the closing costs remain consistent between 8 to 9% for a seller. 8 to 9% for a seller. So fortunately, some of the changes or some of the verbiage changes don't greatly impact the seller's obligation when it comes to closing costs. Possession is not addressed, other than if there's tenant in occupancy. So possession prior to closing, possession after closing. Again, that's pushed to the purchase and sale agreement. with the addenda that exist in the FARBar purchase and sale agreement. And just a point of clarification, while there is a pre and a post addendum in for the purchase and sale agreement, it does not preclude, neither of those addenda preclude the necessity to have an attorney draw up an actual agreement, because the addenda for FARBar, and remember there was no addendum for NEFAR, but the addenda for FARBar don't address all of the different pieces, like who's responsible for what, when do you get out. And remember, timelines on FARBar go to 11:59.59 p.m. So all those things need to be addressed in a formal document, an occupancy document that's drafted by an attorney. But again, it's not in here. Possession is not in here other than to disclose tenancy or the existence of a tenant. Financial representations are not addressed. Financial representation is not addressed in the FARBar. In other words, currently in NEFAR, we say, yes, I will, based on the price that we're suggesting, I can get out of this, I'll be able to pay off all of my debts, or no, I can't, to indicate whether it's a short sale, and then add a short sale addendum. Not in here. So you're going to have some discussions of whether or not this is going to work for your seller, for the seller, at the price that you're discussing. How does the seller feel about their obligations? That's going to be something you really do want to bring up, because at the onset of this, we need to know whether this is potentially a short sale, because there's a lot more that has to be done. Plus, if it's a short sale, it impacts how offers are presented back to not only the seller, but the third party. And remember, please, that the third party in a short sale situation, be it the bank or an investor, is not a party to the contract. They are a contingency in a contract. So we have to watch for that. What else is not in the FARBar? Addressing whether or not the property is assumed to be displayed in electronic media. The address of the property is assumed to be displayed. Remember, in NEFAR, the seller had the choice to say, I want my address displayed, or I don't want my address displayed. And this is actually a good thing, because you've probably heard me say it multiple times. If the seller chooses not to display the address, that potentially eliminates certain websites from carrying their property. So in the FARBar, it is assumed that the address of the property will be displayed on all electronic media. Not a bad thing, just something to be aware of if they ask. The seller's obligations do not include the disclosure of audio or video recording. So there is no disclosure currently within the FARBar. Related to the disclosure of audio or video recording. However, when you put the listing into MLS, there are fields in MLS that ask about audio and video recording. So it's a discussion that you're going to have. And I think this is where there's going to be a little disconnect. We're used to having some of these discussions, whether it be financial representations or audio or video, or the discussions about external websites. We're used to having those discussions in fairly great detail with the seller during our consultation and at the time of signing the listing agreement. We're still going to have those discussions, but it's not followed through in the document. We're going to have separate discussions and make sure that we know that we're having those discussions, or be open about those discussions. There are no HOA details. There's nothing related to the HOA. It doesn't say whether it's in an HOA or CDD. So we have to ask those questions. And then we have to use the amendments that exist to add those even to the listing agreement. I would probably recommend putting them into the additional terms and conditions in the listing agreement, just to note that you have brought them to the attention of the seller. You obviously want to have them signed by the seller at the time of listing, so that you can enter them into MLS, so that you can remove one of the hurdles in getting to contract. Because remember, well, it was stated in the NEFAR purchase and sale agreement. It's not stated in the FARBar purchase and sale agreement. But until you have all of those documents, every required document, you do not really have a contract. So if you get a purchase and sale agreement executed, but the property is in an HOA and you don't have a fully executed HOA addendum, you really don't have a fully executed contract. I've heard agents say, "Oh, we'll just get that signed um, at closing." No, because technically you really don't have a fully executed contract without those required addenda. And then what if someone puts in an offer that's different and more enticing to the seller than your already executed offer? Now, cases could, of course, be made for, well, we were all acting as if we were under contract. So technically, I guess we were under contract. But why would you leave that to chance? So you want to get those additional documents executed with the seller. You can attach them in MLS. Make sure that those documents are a part of the purchase and sale agreement. So the fully executed purchase and sale agreement and documents become your fully executed contract. But again, that's why we're going to want to make sure that when we're doing our listing agreements, that we include any additional addenda and maybe put those into the additional terms and conditions. Damages are set to the listing brokerage percentage. So in the NEFAR purchase and sale agreement, we could fill in the blank as to what we felt were appropriate for damages. In the FARBar, it's already set to be a specific amount would be the listing brokerage fee. Material facts and defects are the obligation of the seller and are not detailed. So all it says about material facts and defects, in other words, the NEFAR purchase and sale agreement has a bunch of lines, a bunch of blank areas and a bunch of disclosures related to rate on gas, energy efficiency, and then additional disclosures related to the property. That doesn't exist in the FARBar. Basically just says it's the obligation of the seller to disclose these things. So while some things are pushed back to us as agents, there are things that are pushed back to the seller, but guess what? If it's pushed back to the seller, it's also our obligation to make sure we have those discussions. We can't go, oh, well, no one ever said anything. I never asked. Um, so we make sure material facts and defects, we have to have those discussions with the sellers and make sure that we're aware if there's anything that could potentially be a disclosure item. The protection period is not defined. When I say protection period, in the current NEFAR purchase and sale agreement, if by chance someone sees the property while we have it listed and then the listing contract expires, if that person comes back and purchases the property within a 12-month, or if there's a change of title to someone who saw the property during the time that we had it listed, it's a 12-month window, which we are able to go back and say, hey, you owe us because we were the procuring cause on this. That time frame, that 12-month time frame is not defined in the FARBar. It's a blank. So we'll have to set a policy. That is lines 286 to 311 are the disclosure, and then the protection period is, we'll go through the listing, we'll go through it in more detail. I'll show you where it is on there. But the protection period is not defined. It's a blank that you fill in. I think it's under, still learning my way around. I don't remember the paragraph. So I'll point it out when we get to it in the listing. All right, so things that are in the FARBar that I think are good things that are good reminders for us. The seller waiver of entry is really within the listing agreement. It's nice because it defines what public marketing is very clearly, and it states, if there's any public marketing, if the seller has agreed to not have the property in MLS, it indicates that the property must go into MLS within 24 hours of public marketing, defines that. So it's a good thing. The seller waiver is in there. I will let you know that Real MLS Policies has elected to keep the waiver of entry. And they've also elected to keep coming soon. Those are really, so far, the only two documents that they'll be keeping right now. Could that change? Yes. Depends on what the new listing agreements and purchase and sale agreements look like after the end of May, probably middle of June. The lockbox addenda is already written into the listing agreement. It's much less detailed, but it is there. The mortgage assumption addenda is contained within the listing agreement. So a few of the addenda that we have are already contained within the FARBar purchase or listing agreement. It does protect the agent when the seller would like to offer seller financing. So it indicates, if you're offering seller financing, it protects you, and then it gives a notice to the seller about what the seller's obligations are and the potential for the seller to be held liable, even when they're doing seller financing. It does define public marketing. So defining public marketing is very important. Why? Because if a seller elects to keep something out of MLS, then when it goes public, it has to be put into MLS. So that's clear cooperation. Clear cooperation allows everyone to have an opportunity to sell that property. And remember, same thing we talk about a lot. If I've got a listing and I'm only marketing to people in my brokerage, which is the requirement of the seller waiver, you can't go outside of the brokerage. If I'm only marketing internally and I would get an offer and someone comes in and now there's nobody else has had an opportunity to make an offer out of that 11,000 or 12,000 other realtors, did we truly get the best terms and conditions for the seller? So taking a look at that becomes important. But it really defines public marketing, brings it right up to the front. So you don't have to define it for the seller. It defines it for the seller, and it puts everyone on notice that we have to put it into MLS. Provides permission to share the listing CMA with the buyer. I thought that was very interesting. We use our CMAs to help guide a seller to arrange and allow the seller to go ahead and pick the pricing on it. But giving our CMA, sometimes that's kind of sacred stuff. So giving the CMA out, it does provide us the right to give the CMA to the buyer. So that would be when requested. Damages are defined to a dollar amount only, not a percentage. So damages, in other words, damages that we believe that we would be entitled to. Currently, we put it at least our listing commission. So that's interesting to have that opportunity there for just a dollar amount. So again, we'll probably set policies to help guide you through some of that. Dispute resolution is set to mediation and arbitration. Since 2000, mediation has been required to be offered by all boards. So we do have mediation and mediators within our board. The cost is minimal or free to members. So this document pushes, or the FARBar listing agreement pushes to disputes being resolved first by mediation, then by arbitration. Because that's covered by Article 17, of the Code of Ethics, which deals with how we manage disputes over monetary means. So those are kind of some of my observations. Bonnie's here with me. I don't know if anybody else has joined us online, but do you have any questions based on what we're saying so far? Okay. Does that help a little bit, I hope? I mean, this will be posted in the YouTube channel. So the slides will be there for you to review, as well as the rest of the recording. What I did want to do is just really go through the listing agreement, excuse me, at this time, to kind of point out things that I'm observing, that I'm thinking you probably will observe and are curious about. So let's go ahead and take a look at that, just in general terms here. So exclusive right of sale listing agreement. The good thing about that is that that's consistent, and that I'm going to expand this a little bit, bring it down a little bit, so we're kind of a little more focused. That means that we're the only ones who have that listing, which is good. That's what we want to be. I mentioned that it doesn't say transaction brokerage. I'm going to scroll a little bit. Where that comes into play is here in paragraph 10, where the first thing it says is as transaction broker. So we'll act as transaction broker, and then defines the responsibilities of transaction broker. Did the NEFAR listing agreement do that? Yes, it defined the relationship, but at the top of the listing agreement, it was very clear that it was a transaction brokerage listing agreement. So really no differences here. Seller is the seller, the broker is the brokerage, the legends of real estate. Remember, please, just as a heads up, start thinking about, do I have the right people? So who's on the deed? Where can you see the deed? If you go to MMT and you look at the tax record, there's a blue link that'll take you to the deed. You can see the deed right online. If you're talking to the person that's on the deed, that's great. But you also need to ask the person on the deed, is there anybody else we need to be talking to? Is there anybody else that needs to be a part of this? I think that's important that we ask those questions. The authority to sell, really nothing major difference. Collectively as the property, this would be your start date of your contract. However, remember the execution date is what really kind of defines the contract itself. So again, if your execution date were today, being the 21st of May, but the term started June 1st, we would need to cover that window between today and June 1st. And I'll show you where that is in here. End is the termination date, cancel date. So in MLS now, with the revisions, it's a cancellation date. So that would be the termination date or expiration date. Upon full execution, so we know that upon full execution, that means signature or the sale and the purchase and sale agreement, all rights and obligations of this agreement will automatically extend. Really no difference here. Slight difference here. This property will be defined, or excuse me, will be offered to any person without regard to race, color, religion, sex, handicap, familial status, national origin. So right there, that's already different. That's federal definition. The NEFAR listing agreement did include sexual orientation and sexual identity. The FARBar does say, or any other factor protected by federal, state, or local law. Well, neither of those two additions that were in the NEFAR are protected within the Jacksonville metro area. So that's a little bit disappointing. I'm hoping that the revised one will expand it to be to include sexual orientation, sexual identity. The seller certifies and represents that she, he, it is legally entitled. So I mean, they do take into consideration DEI here. Is legally entitled to convey the property, but we do need to make sure that we're talking to all the right people. Description, not much different. There is the C attachment, for example, if the legal description is longer, you can add C attachment, not a problem. And that would be, for example, if you had a seller selling multiple parcels and the descriptions were long descriptions, you could put those onto a separate piece of paper and add those to it. There's no formal paper that you would need to use. Personal property. So we jump right into personal property, but notice no definitions, no wall mounts, no draperies, no hardware, no blah, 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 nothing here. Personal property, including appliances, these couple of lines, and then C attachment. Again, not so sure that I would recommend using the MLS profile sheet because most MLS profile sheets indicate that they're what's it say down at the bottom, deemed reliable but not guaranteed. So that's something to consider. How are you going to define what stays, what doesn't stay? Again, this is pushed a lot to the purchase and sale agreement. Occupancy, the only thing that's discussed in occupancy, currently our occupancy discusses how long or when the seller will be providing possession, and then also occupancy. Can they get in? Is it rented? Is it not rented? And there's a lot of detail on the listing agreement. This occupancy is it or is it not rented? Is there or is there not a tenant? Doesn't even ask about the details of the lease, just when the lease expires. I think what we're going to have to do is if it is a tenant occupied property, we're probably going to have to write into offers as we move over towards FARBar documents. We're probably going to have to write into offers that we would like a copy of the agreement, the rental agreement within 5 days of going under contract. I don't remember if that's included in the purchase and sale agreement or not, so we'll have to check. Offered at whatever price, no acknowledgement. However, there is acknowledgement on each page, so that would be considered acknowledgement of the price. And then financing terms, what's available or other, if there's seller financing or if there's an assumption. Currently, what you're used to is if it were either of these options, there is an addendum that is required from the on the listing side as well as on the purchase and sale side. But this is just an indication of what the seller is willing to do. I would probably, again, my recommendation would be to use the seller financing addendum and go ahead and have them fill that out up front so that everybody has an idea of what they're planning on doing. But it does put the seller on notice that if they're doing financing, they may still have liability and that they need to speak with someone if they have concerns. Seller expenses. All it says, seller will pay mortgage discount or other closing costs not to exceed. So if they are willing to pay something towards the buyer's closing costs or down payment or points, this is what their expectation would be. Remember, it varies by lending type. So this would be the maximum, I would believe, that a seller would be willing to contribute towards a buyer's closing costs. But of the purchase price and any other expenses the seller agrees to pay in connection with the transaction. So we've seen the purchase and sale agreement that the seller closing costs are defined in paragraph format, very similar to the check boxes that we've experienced through the NEFAR listing agreement. Well, actually, in the listing agreements, it's a paragraph also. So very similar, except it doesn't define them here. It does go into detail on the multiple listing service. So placing the property in the multiple listing service is beneficial to the seller. This is a statement that's made in the seller waiver of entry. Our current seller waiver of entry will be exposed to a large number of potential buyers as an MLS participant. Broker is obligated to enter the property into MLS within 1 business day. So it really defines that so that the seller and ourselves are on the same page about when it has to be in. 1 business day of marketing the property to the public, right? So seller waiver of entry is automatically withdrawn when a property becomes publicly marketed. Same thing here. If you're choosing not to put the property into MLS, if it hits public marketing, you've got to get it into MLS within 24 hours. And it does reference paragraph 6A, which we'll get to in just a second, or as necessary to comply with local MLS rules. The listing will be published accordingly in the MLS unless the seller directs the broker otherwise in writing. Again, back to paragraph 6. Seller authorizes the broker to report to the MLS the listing information and price, terms and financing information of any resulting sale for use by authorized board, association members, and MLS participants. Very similar to what is under seller obligations, or excuse me, broker obligations in the current NEFAR listing agreement. I'm looking at my notes for page 1. Again, broker obligations are very broad. We are definitely going to need to have a more defined marketing plan for our sellers. It does pull the separate addenda that we've been using for NEFAR for seller financing and assumption out. So it already puts it into the listing agreement. One other thing, sorry, back up here. When we're talking about the property, it says see attachment. So currently in the NEFAR listing agreement, if you are listing a mobile home, you would need to include the vehicle identification number or VIN number. If you are listing a mobile home with the FARBar listing agreement, you're going to have to click see attachment and identify vehicle identification. So you will have to still include that vehicle identification number, or you could put the vehicle identification number into the catch-all paragraph, which used to be paragraph 14, and it is still paragraph 14. Great, I don't have to remember a new paragraph. All right. So that's kind of page 1, a couple of the observations from page 1. Let's move on to page 2, unless I've got any questions. Or you okay? All right. So the broker authority, so it's slightly different here. It does outline very similar items to what the NEFAR listing agreement shows. Market the property to the public unless limited in paragraph 6BI, or 6B1, I guess, below. It defines public marketing, which includes but is not limited to flyers, yard signs, digital marketing, public-facing websites, brokerage website displays, IDX, vowel, email blasts, multi-brokerage listing sharing networks, and applications available to the greater public. So it's really anything that the general public can see is considered public marketing. Public marketing also includes marketing the property to real estate agents outside of the broker's office. Remember, this is exactly what the seller waiver of entry was stating, that when you have something that is not in MLS, in other words, a seller waiver of entry, so that time, for example, from when it's executed to when you're going to start public marketing it, we have to cover that time because it's still supposed to be in MLS within 24 hours. So that time has to be covered. Can we talk about it internally? Absolutely. If a property is under seller waiver of entry, we can talk about it to anyone within our brokerage. And there are a couple of other brokerages out there that kind of push this limit. Actually, they just blow the limit away. They start calling agents that they know in other brokerages. I've got this listing, it's not hitting the market. Do you have anybody type of thing? And that's a violation. That's actually now public marketing. So it should have been in MLS within 24 hours. Place appropriate transaction signs on the property, except in paragraph 6B1, which is the paragraph related to a waiver of entry. Use the seller's name in connection, so all very similar. Here we have a checkbox, display the property on the internet except street address. So it's assumed that the street address will be there. If they click on this, remember you've got to go to broker distribution in MLS to ensure that the street address does not get displayed. We do a lot of things currently in our listing agreement when we say, what is it? Don't display the address, or no comments, or no AVM, but you have to make those changes to the broker distribution when you're putting a listing into MLS. You have to go to that fourth tab, which is broker distribution, make those changes appropriate to what the seller requests. Again, still stand by the fact that if a seller doesn't want the address, doesn't want the third-party comments, doesn't want AVM, there are going to be sites that don't take that listing. You need to make sure that your seller is clear on that, because the first time they go to a website that doesn't take the listing because of that, they're going to call you and say, how come my listing's not on this website? And you're going to have to share with them, well, you selected not to do X and Y, so it's possibly not going to be there. Excuse me. The seller understands and acknowledges that if the seller checks 6B1, the broker will be limited in marketing the property only to agents within the broker's office. Again, perfect definition of seller waiver of entry, and they have to sign. This they will have to initial all the time. Why? Because did you check one of these or did you not check one of these? Excuse me. This is your seller waiver of entry right here. Not publicly market to the public, seller opt out. So if they check this or if they don't check this, they still have to initial here. If they check this or if they don't check this, they still have to initial here. Why? They have to acknowledge what we did or did not do. Again, right here, seller waiver of entry. This is the seller waiver of entry right here written into the listing agreement. Our other obligation, obtain information relating to the present mortgage or mortgages on the property. So we have the right to make those calls. That means they have to give us the information though. So we have to get the lender information. Provide objective, or of course do a pre-title search with the title company that you're considering using for closing. Provide objective comparative market analysis information to the potential buyers. So the seller says it's okay now, automatically says it's okay for us to provide our CMA. Check if applicable, use a lockbox. So here's our lockbox addendum. Use a lockbox. So again, they'll be initially at the bottom. A lockbox does not ensure the property's security. Seller is advised to secure and remove valuables. Seller agrees that the lockbox is for the seller as a benefit and releases the broker, persons working through the broker and broker's local realtor board association from all liability. A little more defined, pulls pieces out of the lockbox addendum. So the lockbox addendum in the listing agreement, NEFAR, that you check is just yes or no. Then the addendum goes into greater detail. Here, we check yes, and then it goes into detail. You can see your options on withholding verbal offers and withholding all offers once the seller accepts sales contract, so I won't be bugging you about initialing that anymore because they're going to have to initial at the bottom of the page. Excuse me. Acts as a transaction broker. So paragraph 10 and right here in our broker obligations defines us as transaction brokers. Virtual office websites. So these are the AVMs, these are the distribution, the electronic. Currently, what you're probably familiar with is electronic display. This is that paragraph here, which talks about, some real estate brokerages offer real estate brokerage services online. These websites are referred to as virtual office websites, which is what we have. An automated estimate of market value or reviews and comments about a property may be displayed in conjunction with a property on some vows. Anyone who registers on a vow may gain access to such automated evaluations and comments and reviews about any property displayed on a vow. Unless limited below, a vow may display automated valuations and comments. So here's where the seller chooses. They do not authorize the automated estimate, or they do not authorize parties to write comments. So, you've gotta, the assumption is that it's going to be there. If they say no, remember, you've got to change that in the broker distribution. They don't want either of those. You've got to change that in the broker distribution. So that's all for the broker authority. In the NEFAR purchase listing agreement, it's much more detailed and much longer. For the broker obligations, I like that it defines the public marketing so everyone's aware, seller and yourselves. It opens that discussion up if you're pulling it out of MLS for any period of time. The assumption is that the address will be displayed. So that's great. You would have to check that it would not be. Seller waiver and lockbox addendum included. I think it's very similar, but just not as detailed. And it puts the onus on us to do a few different things. So let's go back down to the seller obligations. So in consideration of the broker's obligations, the seller agrees to cooperate with the broker in carrying out the purpose of the agreement, which is hopefully to sell the property. Recognized broker may be subject to additional MLS obligations. So this is referencing our MLS rules. Provide the broker with keys to the property. What a novel idea. And make the property available to the broker to show during reasonable times. Reasonable times for unreasonable people, right? Just kidding. Inform the broker before leasing, mortgaging, or otherwise encumbering the property. Absolutely. Indemnify broker and hold broker harmless for losses, damages, costs, and expenses. This is our hold harmless here. That's very similar to the one in the NEFAR listing agreement. Perform any act reasonably necessary to comply with FARBar. So this is a FARBar in the Foreign Investment and Real Property Tax Act. The FARBar paragraph is a little bit longer and defines what the obligations are when you're working with an individual who may be a foreign investor. The seller will immediately inform the broker of any material facts. So remember, this part especially, I'm sorry, back up. Make all legally required disclosures, including all facts. So here's the material facts and defects section, which is much longer in the NEFAR listing agreement, including all facts that materially affect the property's value and are not readily observable or known by the buyer. Seller certifies and represents that the seller knows of no such material facts, local government building code violations, unobservable defects, etc., other than the following. So you get one line here, where you had like 3 paragraphs in the NEFAR listing agreement and like 3 lines on each. So the seller will immediately inform the broker of any material facts that arise after signing the agreement. This might be a great place to talk about the importance of a pre-listing inspection. Or once we get an offer and there's an inspection, all of those items could potentially be disclosure issues. So preparing them for the process. Consult appropriate professionals for related tax, legal, property condition, environmental, foreign reporting requirements, and other specialized advice. So very similar, not huge. Definitely NEFAR is a little bit longer here. All I really noted on here was it's a whole lot of less detail in the material facts and defects and FERPTA. So don't think there's too much. Similar intent, just not as much detail. Any questions you got on page 2? Okay. Let's move over to compensation. So the seller will compensate the broker as specified below for procuring a buyer who is ready, willing, and able to purchase the property or any interest in the property on the terms of this agreement or any other terms acceptable to the seller. The seller will pay the broker as follows. So it breaks it out a little bit differently. So currently it's saying a specific percentage of the total purchase price plus, so this is where the transaction fee would go, brokerage fee would go, or a flat amount. No later than the date of closing in the sales contract. However, closing is not a prerequisite for the broker's fee being earned. So exclusive right of sale listing agreement, if they do not either accept an offer at these terms or conditions or they go under in default, then we're covered to potentially get our fee. Here's where it's a little different. So it's a fee or a dollar amount or a percentage of the consideration for an option. So this would be a lease option to purchase, is what they're speaking of here. At the time of the option is created, if the option is exercised, the seller will pay the broker the paragraph 8A fees, less the amount broker received under this subparagraph. So for a lease option, we can claim compensation for the lease portion. However, what this states is that if the lessee closes, in other words, if the tenant closes, we're entitled to our fee, but it would be minus what was paid as a portion of the compensation for the lease. Which, if by chance they lease the property, so this is that section that I usually hound you about to put in 10%. So a percentage or a flat fee amount of the gross lease value as a leasing fee on the date the seller enters into a lease agreement to lease, which a lease or a lease agreement to lease, whichever is earlier. The fee is not due if the property is or becomes the subject of a contract granting an exclusive right to lease the property. So we need to be aware that if the seller decides to go ahead and lease the property, we do have the rights to get to be compensated. Then there's the definition of when we get it. So this is that exclusive right of sale. Broker's fee is due the following circumstances: if any interest of the property is transferred, whether by sale, lease, exchange, governmental action, bankruptcy, or any other means of transfer, regardless of whether the buyer is secured by the seller, the broker, or any other person. We're also entitled to be compensated if the seller refuses or fails to sign an offer at the price and terms stated in this agreement, defaults on an executed sales contract, or agrees with a buyer to cancel an executed sales contract. So in other words, if they're going to try and maybe push us out. If within a certain number of days, so remember, currently the NEFAR listing agreement says 12 months, within a certain number of days after termination date, which is called the protection period, the seller transfers or contracts to transfer the property to the property or any interest in the property to any prospects with whom the seller, broker, or any other real estate licensee communicated regarding the property before termination date. However, no fee will be due the broker if the property is relisted after the termination date and sold through another broker. Same, except that this date is defined by the brokerage. So we'll help guide you through that. Retaining deposits, what's covered here is that we're entitled to a certain percentage. Currently, the percentage is 50% in the NEFAR listing agreement. The default here is 50%. We'll provide you guidance with that. I would imagine that we'll stay with the default. Now we're going to talk a little bit about cooperation and compensation. Let me just check. No, just no other notes really on that paragraph other than, remember that it's not a year and we'll help guide you through them. Cooperation with and compensation to other brokers. So notice to the seller, the buyer's broker, even if compensated by the seller or the broker, may represent the interests of the buyer. The broker's office policy is to cooperate with all other brokers except when not in the seller's best interest and to offer compensation in the amount of. So we say a percentage of the purchase price or a flat fee. And here we say to a single agent. Same thing, percentage or flat fee to a transaction broker. Same thing, percentage or a flat fee to someone with a no brokerage relationship. So similar to what we currently have, ours is lined out a little differently. This is in paragraph format. If none of the above, in other words, if they do not intend on cooperating with any of them, then we would check none of the above. And it says refer to the local MLS. However, this is one of the things that's being changed with the settlement. In other words, the flexibility of the seller to not offer compensation or cooperation, or excuse me, to not offer compensation from the seller to the buyer's brokerage. It then defines our cooperation. So I don't think there's anything in there. Current shows cannot be placed in MLS. Our current listing agreement shows that if there's no compensation, it can't be placed in MLS. That is, of course, being eliminated because of the settlement. Same thing would be here, or referring to the local MLS rules. Brokerage relationship. So again, reinforces we're a transaction broker and gives the duties of a transaction broker. Then we've got our conditional terms. At the seller's request, the broker may agree to conditionally terminate this agreement. If the broker agrees to conditional termination, the seller must sign a withdrawal agreement. So this is the amendment to the listing agreement. Withdrawal agreement. So we'll have to check for an additional withdrawal agreement. Reimburse the broker for all direct expenses incurred in marketing the property and pay a cancellation fee of. So we can preset plus applicable sales tax. The broker may void the conditional termination and the seller will pay the fee stated in paragraph 8A, which is our compensation. Dispute resolution. Notice it talks about the agreement will be constructed or construed under Florida law. All controversies, claims, and other matters in question between the parties arising out of or relating to this agreement or the breach thereof will be settled by first attempting mediation. So here's your push for mediation under the rules of the American Mediation Association or other mediator agreed upon by the parties. If litigation arises out of this agreement, the prevailing party will be entitled to recover reasonable attorney's fees and costs unless the parties agree that disputes will be settled by arbitration. So again, push for mediation first, then arbitration. In the current agreement, it talks about an interpleader, and it discusses the other options that would be in effect if a brokerage is holding a binder. So initial at the bottom of the page, then there is the acknowledgement of complete agreement, and on paragraph 14, any additional terms and conditions. So this would be a lot to put in here if you're going to list all of those items for personal property, or I would probably recommend in here things that would be movable as it relates to personal property and give them a brief description. Again, the other things that can go into additional terms would be if there's an exclusion from the listing agreement. We don't recommend exclusions, or if an exclusion is taken, for example, an exclusion to, there's something to exclude a particular party, then I would recommend that that be placed in here and it be under a limited time. Can't think of anything else. Just, some of the things that you may want to make sure get covered from things that are no longer in the NEFAR, because I will tell you that despite the fact that some of those items, the items that we identified that are not in the FARBar purchase and sale listing agreement, FARBar listing agreement, but are in the NEFAR listing agreement, we still have an obligation for those items, right? We still have an obligation to have those discussions with our sellers, with the sellers. So maybe make note of them. This is where you may also want to make note of the addenda that you're having them complete at the time of listing. Might be a good thing for that. I don't know, anything else you can think of to put in here? Okay. Then the seller or sellers sign, and then you sign on our behalf. behalf of the brokerage, and a copy must be returned to the seller. So if you're using app files or another electronic signature program, when everything is fully executed, it goes back to the seller. Or they get a notice of full execution. So um, I would imagine this would be you'd need to put in here the date that everything was fully executed. Seller and associate need to initial the bottom of each and every page, so there's a lot of initialing. So when you sign, you also initial. And I think that kind of is a review of the listing agreement. So thoughts? Yeah. So since it's just the two of us here, I don't see anybody else that's jumped on. Um, I'm going to go ahead and call it for us. That's okay. I will go ahead and make sure that this gets into the um, into where is it? The YouTube channel. I'll make sure that the recording gets up to the YouTube channel. If I could remember things, that would be great. Otherwise, if you go over this and have questions, just reach out. I'm sure we'll all be learning more things as we go and making recommendations. But if you think of stuff, let us know. I'm going to go ahead and stop the recording now. And